Supreme Court judgment in Case 2023-2430A. A union representative assisted a work colleague in a meeting with, among others, an HR manager, where the colleague was given a warning. The next day, the employee representative sent an email to a manager in the company, criticizing the HR manager's conduct in the meeting. The email read, "Hello. See appendix above. Was at a meeting with X regarding personnel matter between supervisor and employee yesterday. Is slightly shocked about how I, with his vague information, repeatedly harassed F with claims that X and H had a source that was credible and that F's explanation was a lie. F has consistently denied guilt in the case. F has been employed by Nortura for 42 years. He was given a verbal warning without the opportunity to defend himself. X believed that this warning was the company's attitude on the matter. The warning was completed when F and X came to the meeting. That is, we got the impression that it didn't matter what we meant in the case. Is this the way Nortura wants to appear? Judge, jury, executioner for his employees. So let's hope that their whistleblowers spoke the truth. Innocent until proven otherwise? And Lieutenant, in its method, is guilty until proven otherwise. My words about you are arrogant, unkind, disrespectful. Regards A. Sending this to you and hoping that you can contribute to improvement for the future by having a chat with I." The Supreme Court has concluded that the email is a notification under the Working Environment Act, as it expresses more than that the employee representative disagrees with the company's warning to the colleague. It describes conduct that would be contrary to a rule in the company's labor regulations regarding considerate and proper conduct. The Supreme Court is based on the fact that the concept of warning in the Working Environment Act is broad and includes statements made by employees, including employee representatives, that must be interpreted in such a way that they report censurable conditions in the enterprise. Censurable conditions are matters that contravene legal rules, written ethical guidelines in the enterprise, or ethical norms that are widely supported in society. The judgment of the Court of Appeal, which was based on the fact that the email is not a notification, was therefore quashed. It will now be up to the Court of Appeal to decide whether the company has breached the prohibition on retaliation against the employee representative, and if necessary award compensatory damages. One Supreme Court justice dissented, saying the email did not constitute a notification. The judgment clarifies the content of the Working Environment Act's concept of warning. My view on the matter. Overview of the provisions of the Working Environment Act on whistleblowing. With effect from 2007, the Working Environment Act introduced separate rules on whistleblowing. The rules are based on freedom of expression, cf. Article 100 of the Constitution, which also benefits employees. The purpose of the new whistleblowing rules was to signal that whistleblowing is both legal and desirable, as well as to promote transparency and contribute to a better climate for freedom of expression in the individual enterprise. See Odelsting Proposition No. 84, 2005-2006, page 7. This is in accordance with the purpose of the Working Environment Act, which is, among other things, to facilitate a good climate for expression in the company, cf. Section 1(1) letter C. On page 37 of the proposition, it is emphasized that it may be in the interests of both society and the individual enterprise that censurable conditions are uncovered, and further that a healthy and open communication culture can contribute to a good working environment. The rules were amended in 2017 and moved to a separate Chapter 2A of the Act. The rules were also amended in 2019 with effect from 2020. The main rule in the first sentence of Section 2A(1) has in reality remained unchanged since 2007. Employees have the right to report censurable conditions in the employer's activities. In 2019, the second paragraph was added. It contains a definition of what is meant by censurable conditions. Section 2A(2) states that the employee can always report internally, typically to a representative of the employer. There are also rules on external whistleblowing, which are not applicable to the case here. There are two main effects of the employee reporting in accordance with the aforementioned rules. First, the employer is subject to an activity obligation pursuant to Section 2A3. The employer must ensure that the notice is adequately investigated within a reasonable time. The preparatory work emphasizes that the employer is not supposed to be obliged to carry out a more thorough investigation than what the notification actually provides a basis for. See Proposition 74 to the Storting, 2018-2019, page 36. Second, Section 2A4 prohibits retaliation against the employee who has reported. Any adverse act, practice or omission resulting from or a reaction to the employee reporting is prohibited. If the prohibition is violated, the employee is entitled to redress and compensation without regard to the employer's fault. Cf. Section 2A5. Pursuant to Section 2A6, the employer is obliged to develop procedures for internal whistleblowing if the enterprise regularly employs at least 5 employees. These procedures cannot limit the employee's right to report. It follows from paragraphs 1 to 9 that the notification rules of the Act cannot be deviated from by agreement to the detriment of the employee. The interpretation of the general rule, the right to report. Section 2A1 of the Working Environment Act has this wording: employees have the right to report censurable conditions in the employer's business. Hired employees also have the right to report censurable conditions in the enterprise to the hirer. Censurable conditions mean matters that are contrary to legal rules, written ethical guidelines in the enterprise, or ethical norms that are widely supported in society, such as circumstances that may entail a. danger to life or health, b. danger to climate or environment, c. corruption or other financial crime, d. abuse of authority, e. unacceptable working environment, f. breach of personal data security. Statements about matters that relate solely to the employee's own employment are not considered to constitute notification under this chapter, unless the matter is covered by the second paragraph. The Act has no further definition of the expression, to blow the whistle. But it can be inferred from both the wording and the legislative preparatory work that there is nothing more in this than to speak up. For example, I refer to Proposition No. 84, 2005-2006, page 7, which states that whistleblowing is a especially type of statements, and that whistleblowing means those cases where the employee speaks up about censurable conditions in the enterprise. The law does not impose any requirements on the form of the notification. It can therefore be reported both in writing and orally and in any context. This also includes statements that are part of the general internal communication in the enterprise. See the proposition on page 32. The only requirement is that the notice be made to one of the parties to whom notification can be made pursuant to Section 2A2, typically to a representative of the employer. Nor is it required that the employee's approach to whistleblowing is justifiable. Such a requirement was in the law until 2019, but was then removed. Certain clarifications were given instead for cases where the employee reports to the public. See Section 2A2, third paragraph. What is meant by censurable conditions is defined in more detail in Section 2A1, second paragraph. The preparatory work shows that the term is intended to encompass a broad scope. See Proposition 78 to the Storting, 2018-2019, page 27. But it must be about a relationship that contradicts a more specifically described norm. Dissatisfaction and criticism about matters that do not contravene any such norm therefore fall outside. See Proposition page 28. The enumeration in Section 2A1, second paragraph, letters A, 2, F, are examples of what the violations may entail. Nortura has argued that a minimum requirement is that the censurable relationship has a certain public interest. Often, the cases that fall under the definition will have such interest. But I don't see that this can be construed as a special condition. Section 2A2, third paragraph, letter B, provides that if a report is made to the public, the censurable conduct must be of public interest. A reasonable conclusion is then that this is not a condition for having the right to report internally. I mention, however, that the third paragraph of Section 2A1 delineates certain notices relating to one's own employment. I will not elaborate on that rule, because A did not express himself about his own employment. Nor is there any requirement that the employee who reports censurable conditions must be able to prove that what is said is true. See Proposition 74 to the Storting, 2018-2019, page 51. An alert can therefore express only a suspicion or a concern. The shelf life will have to be clarified through the investigations the employer is obliged to do pursuant to Section 2A3. In other words, the decisive factor is whether the employee reports a situation that would be reprehensible if what is expressed or suspected is true. It follows from this that a more detailed interpretation of the statement made by the employee must take place in order to determine whether it reports censurable conditions in the enterprise. In this case, not only the employee's choice of words, but also the context in which the statement is made, and the knowledge the parties have of each other, may be of significance. The decisive factor must be whether there are reasonable grounds for the employer to perceive the statement in such a way that it reports censurable conditions in the enterprise. This does not entail any requirement that the employee must express himself or herself clearly. In the event of ambiguity, the purpose of the whistleblowing rules, which are to contribute to a good climate for freedom of expression and to uncover possible censurable conditions in the enterprise, may indicate that the employer contacts the employee to clarify how what has been said should be understood. Nortura has argued that there must be a presumption that when a union representative approaches the employer, it is about matters about which the parties have ongoing communication pursuant to the applicable collective agreement. The role expectation and context then indicate, it is claimed, that the employee representative is not perceived as making a notification pursuant to Chapter 2A of the Working Environment Act. I do not see that there is any basis for making such a presumption. Subsection D of Section 2A2 states that an employee may report internally, via elected official. This means that the employer must be prepared to receive notifications also from the employee representatives. The decisive factor then is, here as elsewhere, how the utterance in question must be perceived. The specific assessment are expressed in the email he sent on 29 June 2021, which I quoted initially, that the HR officer number 1 in the meeting the day before, repeatedly harassed colleague F. It is further stated that this was done by the HR officer citing and building on allegations that the colleague disputed and against which the colleague was unable to defend himself. The message is underlined by strong characterizations of the HR manager's behavior, which is described as arrogant, unkind, disrespectful. The email must therefore be perceived as something more than a disagreement about Nortura's reaction to the colleague. What A primarily describes is strong criticism of the HR manager's conduct in this regard. Whether what A describes is censurable conditions depends on whether it contravenes one of the norms mentioned in Section 2A1, second paragraph, of the Working Environment Act. Section 7.4 of the company's labor regulations stipulates that everyone must act considerately and correctly towards managers and colleagues. Based on its content, this rule must be judged as a written ethical guideline pursuant to Section 2A1, second paragraph. And as I see it, the conduct described by A would violate Clause 7.4 if there is any basis in the allegations. The email therefore describes a censurable situation in the company. I also mention that Section 4-3, third paragraph, of the Working Environment Act stipulates that the employee not be subjected to harassment or other improper conduct. The circumstance described by A may, in the circumstances, be contrary to that rule, without it being necessary for me to decide whether the alternative, contrary to statutory rules, in the second paragraph of Section 2A1 is also satisfied. Finally, I believe that for Nortura there were reasonable grounds for interpreting the email to mean that A notifies, speaks up, of the censurable situation. This is supported by the fact that he concludes by saying that he hopes the email leads to the HR manager contributing to improvement for the future by having a chat with our In other words, he believed that what he says should be followed up by his employer. A sent the email to the HR manager's superior, HR manager G in Nortura Department North. G is undisputed, a representative of the employer, cf. subsection A of section 2A2. Against this background, I have come to the conclusion that A, in his email on 29 June 2021, reported a misconduct in Nortura to a representative of the employer. Conclusion and legal costs. The application of the law by the Court of Appeal is, therefore, improper. The consequence is that the judgment of the Court of Appeal must be quashed insofar as it determines the claim for relief. In its new judgment, the Court of Appeal must decide whether Nortura has violated the prohibition against retaliation in Section 2A4 of the Working Environment Act, and in the affirmative determine the relief pursuant to Section 2A5. A has won the case before the Supreme Court, essentially upholding. The center of gravity has been on that question under the relief claim considered by the Supreme Court and on which A has been upheld. He is therefore entitled to compensation for his legal costs in the Supreme Court, cf. Section 20(2), first and second paragraphs of the Disputes Act. There is no reason to exempt Nortura from liability pursuant to Section 20(2), third paragraph. A has submitted a cost statement of 393,429 Norwegian kroner, of which 379,500 Norwegian kroner is fees paid to the council and the rest are other costs. No VAT coverage has been claimed. I think the costs are necessary, cf. paragraph 25 first paragraph. They are therefore awarded. The costs of the case before the District Court and the Court of Appeal are decided by the Court of Appeal, cf. Section 28, third paragraph, of the Disputes Act. I vote for this one judgment. 1. The judgment of the Court of Appeal is quashed so far as it determines the claim for relief. 2. In costs before the Supreme Court, Nortura SA pays to a 393,429 crowns within 2 weeks of service of this judgment. Judge Ostenson Berglund, dissent. I have a different view of the interpretation of the law and the specific assessment than the first. In interpreting the whistleblowing rules, my point of departure is that the Working Environment Act is a protection act, where consideration for a safe working environment is central, cf. Section 1(1)(a) of the Working Environment Act. Pursuant to Section 1(1)(c) of the Act, a good climate for freedom of expression shall be facilitated in the enterprise, in line with what also follows from Article 100 of the Constitution concerning employees' freedom of expression. Although subsection C was incorporated into the Act as part of the strengthening of the rules on whistleblowing, the provision expresses a general principle intended to help ensure a good working environment. Chapter 4 lays down rules on requirements for the working environment. A number of other provisions in the Act have also been made to ensure a fully satisfactory working environment, including information to and discussions with employee representatives, working environment committees, safety representatives, HSE work requirements, etc. A satisfactory working environment presupposes well-functioning cooperation in the workplace, where there is room to point out errors and deficiencies. As pointed out by Jan Faulkner, Norwegian Labour Law. Governance Law, Cooperation and Worker Protection, 2019 page 820 is the legal system that, conflict resolution and management of working environment problems, presumed to be solved, by means of the general track of prevention and conflict resolution. Cooperation with employee representatives is important here, both in terms of the law and as a result of agreements between the labor market organizations. At the same time, it is clear that this will not always be sufficient, which, together with consideration for freedom of expression, contributed to the inclusion of separate whistleblowing rules in the Working Environment Act, cf. Proposition No. 84, 2004-2005, to the Oddelsting on page 33. Pursuant to Section 2A1 first and second paragraph of the Working Environment Act, an employee has the right to report censurable conditions, i.e. circumstances that are contrary to legal rules, written ethical guidelines in the enterprise or ethical norms that are widely accepted in society. The second paragraph provides a number of examples of what such circumstances may entail. I essentially agree with the former in his interpretation of the wording and understanding of the preparatory work. However, as the former lays out the statutory provision, I believe that the distinction between general criticism and the whistleblowing rules is blurring. I don't see that being the intention of the legislature. Already the wording of the provision indicates that notice is something more than ordinary criticism or a grievance. I perceive the preparatory work as somewhat divergent. Although Proposition No. 84, 2005-2006, page 37 of the Odelsting Proposition No. 84, 2005-2006, it is stated in the sections before and after that notification pursuant to Chapter 2(a) of the Working Environment Act is a specific and specially protected form of expression based on society's need for certain types of information to come to light. As I see it, this supports the fact that it is primarily the general rules in the Act that are intended to ensure that critical voices are heard, but that relatively little is required to report if necessary. In now 2022-9 An Open and Enlightened Public Conversation, the Freedom of Expression Commission discusses in point 15.5.4 the chilling effect of criticism being referred to as whistleblowing. Here it is stated on page 315. If whistleblowing is defined more broadly than the law envisages, it both dilutes the function of whistleblowing and blurs the scope for the normal use of freedom of expression in working life. A misguided use of the term whistleblowing may create the impression that it is not permissible to criticize the workplace unless it is a whistleblowing report. If so, this has a chilling effect on general freedom of expression. A wide scope for disagreement in the workplace could reduce the risk of criticism escalating into a conflict. When criticism is confused with a whistleblower, it may mean that the employer is looking for ways to protect themselves from the report rather than finding a solution to the problem. Although the statements have limited legal source weight in interpreting Chapter 2(a) of the Occupational Health and Safety Act, they nevertheless cover my concern about the first respondent's understanding of the rules. In addition, consideration for freedom of expression was a key consideration when the rules on whistleblowing were introduced. I see the whistleblowing rules as key and important provisions in Norwegian working life, of great importance both for the individual and for society as a whole. At the same time, freedom of expression and the strong protection inherent in the general provisions of the Working Environment Act are fundamental rules that should form the basis for grievances and criticism in working conditions. This indicates that there should be a sufficiently clear distinction between such statements and whistleblowing. The threshold, that is, the limit, for what can be considered whistleblowing should therefore be set somewhat higher than what the first respondent does. I will not go into this in more detail, but I am content to consider the question of whether it is significant for the understanding of whether it is criticism or a whistleblowing report that a matter is raised by a union representative. Unlike the first, I think it needs to be answered in the affirmative. The cooperation between employers and employee representatives pursuant to legislation and pursuant to, for example, the main agreement NHO law is very important for ensuring a well-functioning working life. The employee representatives therefore have special protection to ensure that they can exercise their office in a clear manner. Both the Act and the main agreement give the employee representatives the right to information and discussion of decision-making processes, which contributes to important ongoing communication between the parties. Many employers also involve employee representatives to a greater extent than required by law or various collective agreements. Such cooperation should be supported. If doubt or misunderstanding should constantly arise as to whether something is a warning, this cooperation may be weakened. Communication between employers and employee representatives pursuant to the Act or the collective agreement is characterized by the customary and regular nature of the agreement. Communication in the form of a notification pursuant to Chapter 2(a) of the Working Environment Act is characterized by something more extraordinary. Although there cannot be a presumption that an inquiry from a union representative is related to the cooperation, And even though the employer must be prepared for union representatives to report incidents, I therefore believe that in principle, a different clarity must be required where a union representative makes or communicates a notification, compared to cases where an employee does so. When assessing whether a notification from a union representative is designed in such a way that the employer has reasonable grounds to perceive the statement to be a notification, the content, role expectation and context will be of importance. For example, even though a union representative may report the same matters as from an employee, it is reasonable to expect a union representative to refer to the inquiry as a notification or to use the company's whistleblowing channels, precisely to distinguish the notification from the general interaction the employee representative has with the employer by virtue of being a union representative. For other employees, on the other hand, there may be a need to use other channels. The various factors can be illustrated through the specific assessment in the case. I agree with the first respondent that the email contains expressions that, when taken in isolation, may indicate that it is intended as a notification. However, the email was made the day after as a union representative had assisted another employee in a meeting. It is therefore reasonable to regard the email as a follow-up to this. The use of words must also be seen in light of the fact that has a history of using false expressions. He has been issued a warning several times for his mention of leaders. Parts of the email in question appear to be mere name-calling by the HR manager, and not as a pointing out of censurable conditions in the company. As a union representative, is well acquainted with Nortura's notification routines. In such a situation, there were reasonable grounds on the part of the employer to believe that these would be used. I add that neither in the writ petition he eventually issued on his own behalf, in the subsequent writs of proceedings nor in the preliminary hearing of the district court, claimed that he had filed a notice. This was first argued on 23 May 2022, 3 weeks before the main hearing in the district court. Overall, I believe A's email was not a notification. I have since come to the conclusion that the appeal should be dismissed. Judge Stenvik. I essentially and in the result agree with the first respondent, Judge Falk. Judge Sather. Likewise. Judge Webster. Likewise. After the vote, the Supreme Court in dissent 4-1, ruled. Judgment 1. The judgment of the Court of Appeal is quashed so far as it determines the claim for relief. 2. In costs before the Supreme Court, Nortura SA pays to a 393,429 crowns within 2 weeks of service of this judgment.